Section 19, Property Management, Legal Hotline Q&A, Arizona Market Introduction, From Brokerage Compliance to Property Management Risk. In Section 18, we looked at brokerage legal hotline issues involving broker review, listings, compensation, disclosure, and supervision. Now we move into property management, where the same rules of supervision, documentation, and reasonable care become even more detailed. Property management is a high-risk area because it involves rent, security deposits, trust accounts, repairs, leases, tenants, landlords, notices, and strict timelines. One small mistake can create liability for the property manager, broker, landlord, or tenant. Prepaid rent must follow the agreement. In one legal hotline scenario, tenants with credit issues offered to pay a full year of rent in advance. The landlord accepted, and the lease stated the full year's rent would be paid to the landlord. The property manager was not required to hold the money in the trust account and release it monthly. The rent should be dispersed as the parties agreed in the lease. However, a landlord cannot demand or receive security, including prepaid rent, in excess of 1 1/2 months' rent, although a tenant may voluntarily pay more in advance. Trust funds must stay separate. Another common property management issue is commingling. If a broker receives one check from a collection agency that includes money for client properties, personal rental properties, and closed accounts, the broker must be careful. A property management firm must deposit client monies into the property management trust account within 3 banking days after receipt. Personal funds and client funds should not be mixed. Best practice: require separate checks for personal properties and client-managed properties. Records must be maintained. Property managers must keep financial records for clients for at least 3 years from the date each document was executed. These records include bank statements, canceled checks, deposit slips, receipts, journals, owner statements, ledgers, bills, invoices, and statements. Example: if a landlord asks for 5 years of repair receipts, the property manager may not be required to produce all 5 years, but 3 years of required financial records must be maintained and available. The 5-day notice must be accurate. In one scenario, a property manager gave a tenant a 5-day notice, but accidentally listed a payment deadline beyond the 5-day period. The property manager had to honor the later date because the notice created an expectation for the tenant. Under R4281101, licensees must deal fairly with all parties. Best practice: notices should be reviewed carefully before delivery. A wrong date can delay enforcement. When a landlord changes property management companies, the old property manager should contact the landlord for instructions on how to transfer the tenant's security deposit. If the security deposit is held in the property management trust account, the tenant may also be entitled to notice before the deposit is transferred out of that account, depending on the lease language. Ordering repairs does not require a contractor's license. A property manager acting on behalf of an owner does not need a contractor's license simply to hire a roofing subcontractor or order repairs. Arizona law provides an exemption for property managers and their employees in this context. However, the property manager should still use qualified contractors, document owner authorization, and keep repair records. Closing thought: property management is about systems. Money must go where the agreement says it goes. Trust funds must stay separate. Records must be maintained. Notices must be accurate. Deposits must be transferred properly. Repairs must be documented. If Section 18 showed us brokerage compliance questions, Section 19 shows us that property management compliance lives in the details. Online discussion question 1. Why must property managers be careful with prepaid rent and security deposits? Answer: because prepaid rent and security deposits must be handled according to the lease, Arizona law, and trust account rules. Question 2. Why is commingling such a serious property management issue? Answer: because client funds must be kept separate from personal funds, and mixing them can create trust account violations. Question 3. Why must a property manager honor an incorrect later date listed in a 5-day notice? Answer: because the notice created an expectation for the tenant, and licensees must deal fairly with all parties.